This video is going to be about what to do when you get sued. That's a good question. I'm going to try to answer today. And so I just want to provide some general tips and we're going to get straight to it. The first thing to do if you get sued, and I bet you guess already, you already know what it is. You want to consult with a lawyer in your state or jurisdiction. I know this is common sense advice, but I have to put it out there as my first thing because only a lawyer in your state can accurately provide you with legal advice about your legal situation. A guy on the YouTube video cannot provide you that. A lawyer who's not licensed in your state cannot provide you that. So you definitely want to check with a lawyer in your state. Even if you don't feel like a lawyer is gonna cost more than what your situation is, you might be arguing with someone on $500 and you want to take them to city court. It might be worth it to find a lawyer who would let you pay them a consultation fee to get tips. Okay, what I need to do when I go to court, what should I say, what shouldn't I say? A lot of times in those smaller level courts, people mess themselves up because they're talking too much. They don't know what they're talking about. They think what they're saying is helping them and it's actually hurting them. So no matter how small your situation is, it always helps to consult with a lawyer in your jurisdiction regarding your issue. That's tip number one, consult with a lawyer in your state. Tip number two, when you get sued in a lawsuit and if you get served in Mississippi, if you get served with a lawsuit, you want to answer that lawsuit within the time provided on that summons. If you serve with something called a Rule 4 summons in Mississippi, so it's a summons, you get a lawsuit in your hand, you get served, and on top of that lawsuit, if it's in the big court, it's gonna say, hey, you got 30 days to answer the lawsuit. So that means you need to go consult with a lawyer within 30 days, hire them or get legal advice with them, and respond to that lawsuit within 30 days. That's what that means. Also, in smaller courts like city court, justice court, and there's a lot of family law court, you may get served with a summons and you're gonna have a court date on that summons. And if you want to defend your rights, you want to show up to that court date to defend your rights. Lots of times you can go to that court date and ask the judge for more time, and the judge will give you more time in that family law situation. If it's summons that tell you to answer within 30 days, consult with a lawyer and answer. If it's a summons that says you got to be at court at a certain time, show up to the court date. Because you don't answer within 30 days or you don't show up to the court date, you can and most likely will get a default judgment against you for not showing up to that court date or not responding to that summons in 30 days. So when you get served with a lawsuit and you consult with a lawyer, most likely that lawyer is going to tell you need to answer within 30 days, or most likely that lawyer is going to say, hey, you need to go to this court date and defend your rights. Okay? All right, that's tip number two. Tip number three, this is big in family law situations. If you have to communicate with the opposing party during the lawsuit, you want to communicate in a way that, hey, however I talk to them, I need to say it to them as if it's going to be said again in court. Now, what you say to them, they can't repeat what you say because it's called hearsay. But let's say if you texting them, they might say, hey, I got these text messages from him. He cussing me out. No person like that needs to be around my child, So you want to be careful how you texting and writing people. If you're in a lawsuit and you still got to deal with a third party, text them as in what you're texting is going to be read in court. I tell everybody that in my family law cases. And also, if you just in a lawsuit, if you see something heading towards the possibility of lawsuit, if you're working on a job and you feel iffy about the situation, you think you might have to sue your job, start communicating them in a way that, hey, this email might get read in court one day. Let me do that. Or it might be a camera watching me interact with these people. Let me act in a way that it might get played back in court one day, So you want to email and text as if the situation you in is going to be in court. Contracts, you want to write this contract as it's going to be read in court one day. You want to try to prevent things on the front end. Then if you're in the lawsuit, you want to act accordingly. You don't want your communication to be used against you. That's tip number 3. Tip number 4, this is a big one, because this is a real big one, because a lot of people believe lawyers lie and lawyers encourage liars. I may be real, real passive, but I think at least most lawyers, more than not, don't lie. Now, I have been in court and lawyers are lying through their teeth. Yes, there are lawyers that lie, but I like the majority of them are trying to work out the situation and not lie. Now, they might leave something out, but I would think majority of them don't lie. Now, clients and witnesses, particularly you in your case, you need to get together with your lawyer and figure out how to work through hard issues. Don't lie about it, because if you lie about them and later on it came out that you lied about a situation in court, it can make you a not reliable witness. So don't lie doing testimony. Don't lie to your lawyers. Tell your lawyers about the bad things so y'all can work on it together. Y'all might come up with a way to avoid that issue come trial or come deposition time. Or, the opposing counsel might not even bring up the situation, so you ain't gotta lie about it in the first place. Be truthful with your lawyer. Y'all come up with a good plan on how to avoid this situation and come down to it. Don't lie about it. If you have a good lawyer, y'all gonna work through that 1,000 times to where you come up with a good rebuttal for a bad fact, or a bad statement. So that way you don't have to lie about it. You know what I'm saying? Don't lie. One of the craziest cases I seen when somebody was lying about the situation, and someone lied during the deposition, and so then they found out about it. Because they lied during the deposition, their case got severely weak. Don't lie. That's tip number 4. Number 5, don't post anything crazy on social media. It was a case recently that went famous on the internet and went a little viral. Famous, I sound old saying that. I meant to say it went viral on the internet. Is this lady, she was injured and she was suing this company for damages. But the company lawyers seen the lady in a tree throwing competition. So her case was severely weakened because she was in a tree throwing competition. Granted, it wasn't posted on social media, but it was on the internet. So do not post anything crazy on the internet. It was another case where somebody was supposedly super injured, but they was celebrating something. And when they was celebrating something, they posted themselves celebrating really hard. I ain't gonna tell you exactly what they were doing. Celebrating really hard on the internet. The case was severely weakened because the opposing counsel saying that person was not as injured as they was. So be careful what you post on the internet. When I have a case and I'm suing somebody, I go on people's Facebook pages all the time, even defendants. I'm the one proving damages for my client, the person injured case. But I even go on defendants' pages just to kind of feel what kind of person they are. I'm sure people go on my pages, especially opposing counsel. They're going to go on your page and look on your page, see what you're doing, see can it catch you a lot. Don't post nothing crazy on Facebook. You think that would go without said, but I have seen it on more than one occasion. People posting stuff on Facebook and other social media, messing themselves up. Don't do that. Tip number 6, and this is mainly for a criminal case. In all cases, don't talk to people about your case, about specific facets of your case. You ever seen somebody interview, they going through a lawsuit and they get asked in public, a famous person like, hey, can you tell us about this case? Like, well, I have been advised not to talk about this until it's done. That's what you want to do. Don't talk about it. Situation, your lawyer should advise you don't talk about it. Now, you got certain situations, lots of times in racial discrimination cases, things like that, where people hold press conferences. That's different, that lawyer and that client most likely came up with a good strategy to make it a press conference. In most cases, don't talk to nobody about what happened. Don't talk, especially in criminal cases, don't talk to anybody about anything. If you're in jail in a criminal case, sometimes police set up to talk to you, befriend you, to try to hear about what exactly happened on the case and use that to convict you. Don't talk to anybody about your case or what's going on. Okay, well, I hope y'all enjoyed those tips. I hope those tips help you out. It's just a free tips. It's not tips that apply to everybody, every single case. And again, I am a lawyer, but I'm not your lawyer. These are just general tips. If you have a problem, you need to consult a lawyer in your state. All right, and you want to check out another video of mine, take a look at the video, how to get a lawyer with little or no money. Thanks, guys, and see y'all on the next one.